Crone, and welcome to the Crone Law Firm's Facebook Live chat on employment law. My name is Alan Crone. I'm the founding member and managing member of the Crone Law Firm. We're an employment law firm located in Memphis, Tennessee. And as I always say, our definition of an employment law case is any case that impacts your ability to earn a living. We represent employees, executives, and entrepreneurs. And that can be a wrongful termination case. It can be a case about commissions or compensation, wrongful termination, discrimination, harassment, retaliation. We also handle cases involving disputes between business partners. We call those business divorces, non-compete cases, all kinds of cases involving the employment relationship and people's ability to make money. So thank you for joining us this afternoon, and we're going to talk about the EEOC. The EEOC is an important federal agency, and we've been asked over the years a number of questions frequently about it, and so we thought we'd do a show just about the EEOC and what it means to you. So the first question is, what is the EEOC? That's a great question. And the answer is the EEOC is the Equal in Employment Opportunity Commission. And it was set up during the Civil Rights Act of 1964 as the federal agency that would ensure fairness and equality in the workplace. So any lawsuit or dispute that involves workplace discrimination or harassment must originate under the federal law with the EEOC, the Equal Employment Opportunity Commission. Commission has a board in Washington that meets and decides policy in some cases, and it has a staff spread out over the entire United States in most major cities to collect, investigate, and handle complaints. So what kind of complaints does the EEOC handle? Well, predominantly it handles any complaint arising under the Title VII of the Civil Rights Act of 1964. And so that's discrimination or harassment based on sex, age, race, national origin, or religion. They also have jurisdiction to investigate claims under the Americans with Disabilities Act and for age. I think I said age under the Title VII, but that's a separate statute, the Age and Discrimination in Employment Act, which was passed many, many years before the Civil Rights Act was passed, but the EEOC can investigate age cases. And so one thing to kind of bear in mind with the EEOC is that it has to investigate every federal claim of this nature throughout the whole country. And so they have a tremendous case volume that comes in. And so they have to be very selective in how they use their resources and exactly how they process claims. So that's always important to know when you're dealing with the EEOC, is that sometimes people get a little frustrated with them, but they have a big job to do. And like most things in the government, they don't have nearly as much resources they would like to have to be able to investigate every single claim that comes in. So the next question is, how do I contact the EEOC? Well, the EEOC has a website, eeoc.gov, and that has you can find your local office on the website. As I say, most major cities have a district or regional office of the EEOC, and you can find them in the blue pages of the telephone book for those of you who still have a telephone book. And if you don't, then you can certainly find it online by searching for your local EEOC office. The EEOC's website has a location finder on it that where you can search, tell them where you live, what your zip code is, and it will show you where your closest local office is. So you can file a complaint either online or in person. I really recommend the in-person filing, because then you can sit down and talk with a with an investigator personally. It may take a little bit more time and a little more effort, but I really think that effort is worth it. And what can the EEOC do for me? Well, what the EEOC can do for you really is on two levels. The first level is what I'll call the administrative paperwork level. Before you can file a federal lawsuit against an employer who's covered by the Civil Rights Act of 1964, you have to file an EEOC complaint. And I really encourage people that if you feel like you're being harassed or discriminated against or retaliated against because you've complained about harassment or discrimination at your place of business, and you don't feel like it's getting any better, sooner rather than later, file a claim with the EEOC. And for this reason, your statute of limitations is constantly running on those claims, and the only way to satisfy it is to file with the EEOC. That satisfies your filing requirement, and you can then move on to other steps after that. So that's the first thing is by filing with the EEOC, you satisfy a major requirement under the statute. The second thing the EEOC can do is they have a private mediation process where the parties to the dispute will sit down free of charge with an EEOC mediator, and frequently the EEOC mediation corps has great success in resolving those claims. I've had clients that have gone through that process on their own and gotten acceptable results. I've gone as an attorney, I've represented people, and lawyers in our office frequently represent people in mediations conducted by the EEOC, and they can be very, very productive. Mediation is a process by which a neutral third party can help parties to a dispute resolve the dispute. So that mediator isn't going to decide who's right, who's wrong, how much, how little you get paid, but they're going to help both sides come to some sort of agreement. Every case is different, but it's a process that's worth going through. The whole thing is confidential. Nothing you say in that process can be used against you later. The mediators are in a separate office from the investigators, so it's done completely outside the investigation process, and all that's done to foster resolution of claims. So that's a service the EEOC can provide. The next is they will, if they can investigate your claim. And the EEOC over time develops criteria for claims that they are interested in pursuing. They have claims that they're interested in investigating, and then they have claims that they're interested in taking themselves as the lawyers essentially and prosecuting the case for you. I tell you, I've done employment law for almost 30 years, and I can count on one hand the number of cases I've been involved in where the EEOC has actually taken the case and prosecuted it for the plaintiff. And the reason for that is, as I said before, they have very limited resources. They can't take every case that comes in. There are plenty of employment lawyers, frankly, like me, who are willing to take these cases, so they don't have to take them. So they're very, very selective in the kinds of cases that they take. And just because they don't take your case doesn't mean you don't have a good case. You can have a great case. If it doesn't satisfy their criteria, then they may not be interested in it. For example, during the Obama years, the EEOC was very interested in Equal Pay Act cases and national origin discrimination cases. And so frequently, those were the kinds of cases that got more investigation work and the EEOC picked up. That doesn't mean that someone who went in with, say, a race discrimination or retaliation case didn't have a good case. It just may mean that the criteria for going on to the next level was different for that case. So frequently, the EEOC will investigate. They may send an investigator out to the company and interview witnesses. They're certainly going to interview the complainant. They're going to ask the responding party, the company, to draft a written response to the charges. And that then creates a record that can be used in the case down the road. It'd be very helpful for the EEOC to investigate can investigate a case, and certainly can be very helpful if the EEOC decides to pick up your case and run with it. Because then you may or may not have to hire a lawyer, or at least if you do hire a lawyer, that lawyer may not have to do as much work because the full weight of the federal government is behind the case. I say frequently these days, I think most of the cases that the agency takes are class actions and situations where there are a large number of potential claimants where they can get the bigger bang for their buck, so to speak, where they can have a bigger impact on a particular kind of discrimination or harassment. Next question is, what can I expect after I file a complaint with the EEOC? Well, I always say the thing you need to do is be patient, because once you file a complaint, then it gets put in line for investigation. While it's in line for investigation, it can be selected for their mediation program, which I've described before. And what happens is you will get a letter, the complaining party will get a letter that says, do you want to engage in mediation? And the responding party, the employer, will get a letter saying, do you want to engage in mediation? If both of you say yes, then they schedule a mediation, and the case is removed from the investigative line, if you will, and put in the mediation office. And that's important because it reduces the casework for the investigators so they can move on to other cases, but it also segregates it from the investigators so that they won't be prejudiced by what may or may not happen in the mediation. If you resolve your case in mediation, then it's over, and both parties will sign a release saying that the case has been resolved. And if the employer has promised to pay money, then the money is paid, and hopefully both parties go on with their lives, and it's happily ever after at that point. It may take the EEOC, assuming that the mediation process either doesn't work, doesn't result in a settlement, or the case isn't selected for mediation, then it will be investigated or evaluated. The next step is evaluation. And again, the EEOC doesn't always talk about its criteria, but sometimes the EEOC will look at a case and say, we're not going to investigate it. And they will issue a right to sue letter. And what that means is, if you get a right to sue letter, you then have 90 days from the date that they issue the letter to file a lawsuit in federal court, or you lose your right to file a lawsuit under the federal statute. Sometimes those letters come very, very quickly. I've had them come the same day that the claim is filed. I've had them come years after the claim is filed. Every case is different. The ones that are selected for investigation, the investigator will send a notice to the employer, the responding party, and ask for their response to the complaint, and usually takes 30 to 60 days for that to happen. I find that most lawyers who represent employers usually get the case 2 or 3 weeks after the EEOC has sent a notice, and so they need a little bit of extra time to investigate themselves and figure out what's going on. But then the response comes, and then the investigator may ask for more information, may ask for more documents, may ask to come and interview witnesses at the workplace, or want to interview people off-site. And that really just kind of depends on the circumstance and the investigator. I've also had situations where, when there was a lot of distance involved, the investigator might do some phone interviews. And then at some point, the investigator will determine whether or not the EEOC wants to take the case for litigation. In other words, the EEOC handle the case themselves, or whether it's going to issue a right to sue letter. And that can come in a number of different kinds of flavors. Sometimes the EEOC will say, we find merit, but we're not going to take the case, and issue a right to sue letter. Sometimes they'll say, we don't find merit, and we're going to issue a right to sue letter. Sometimes they say, we don't see it one way or the other, and issue a right to sue letter. The bottom line is, you get the right to sue letter, and then you have the ability to move the case forward in federal court. Frequently, I've had clients that get frustrated with the pace at the EEOC. And all I can say to them is to be patient, and that there's a lot of benefit to the EEOC doing an investigation, particularly if the client doesn't have a lot of financial ability to do their own investigation. So it can be helpful for the investigator to talk to people and get some transcribed interviews and so forth. That can be very helpful down the road. Sometimes I have clients that have done an investigation themselves, or perhaps I've done it for them. They're ready to go to court. They don't want to wait for that. You can then request the investigator send a right to sue letter, and most of the time, the investigators will do that. And just as all cases are different, all investigators are different. They have their different ways of working. And I've found that EEOC investigators can be great allies on both sides of the equation, but particularly if there's a meritorious case, sometimes the investigator can be very helpful in helping to negotiate a resolution of the case that's satisfactory to the complainant. And the last question that we're frequently asked is, do I need a lawyer for the EEOC? Yes and no. I think it's very helpful to have legal help in processing these claims. Keep in mind that the Civil Rights Act of 1964 has what we lawyers call a fee shifting provision, which means that the defendant has to pay your legal fees above and beyond, or I should say in addition to the claim. So if your claim is worth $10,000 and you've got $20,000 in legal fees, then you get a check for $10,000 and less taxes, and the attorney gets a check for his or her fees. It's not like most other situations where a percentage of what you get is taken out. And so you've got very little to lose in hiring a lawyer. And I think it can be helpful in responding to the EEOC. Frequently, even if you're a complainant, they may ask you for information. And so it's helpful to have a lawyer help you marshal that information, put it together, and put it in a format that the investigator can use quickly. The easier you can make the investigator's job, the more anxious she is going to be to work on your case as opposed to another case. Plus, sometimes it's also very helpful to have a person who is just interested in you and your needs, advising you on what everything means and helping you make strategic and resolution decisions. Because at the end of the day, the EEOC investigator works for the EEOC, and most of them want to get a good result for you, but they don't necessarily have the same level of loyalty to you that your lawyer would have. And then finally, I would say getting a lawyer involved early is very helpful because that then helps the lawyer understand your case and build your case along with the EEOC. And as I said, by far and away, the vast majority of cases are not handled by the EEOC ultimately. So if you want to get a result, most likely at some point you're going to have to hire a lawyer. And so you might as well go ahead and do that at the earliest possible moment so that the lawyer can help start adding value from the very, very first day. If you make some bad choices early on, that can affect your ability to get the best settlement or the best verdict down the road. And so a good lawyer can help you anticipate that and deal with it at different junctures of your claim. Well, we could talk for hours and hours about the EEOC and how it works and so forth, but I think this gives you a good idea about the nature and scope of their work and how the EEOC can help you. The one last thing I'll leave you with, and we did a whole show on wrongful termination where we kind of discussed this, but again, this just shows you how kind of narrow the lanes are in employment law. The EEOC is only interested in federal law, there are many state law components that have their own state anti-discrimination laws. Some are very, very robust. Some are not very robust. So you need to understand what the state law is in your particular state, and understand that in many cases, filing an EEOC complaint, while it complies with the federal statute of limitations, very frequently does not toll or stop the statute of limitations on your state law claims. So that's another reason to get a lawyer involved very quickly, because very often the state laws have different remedies, different money amounts you can get than under the federal law. So it's good to understand that the EEOC is going to talk about sex and race, religion, age, national origin, and disability discrimination, harassment, and retaliation. But it doesn't have jurisdiction over the Family Medical Leave Act, the wage and hour laws, overtime, minimum wage, OSHA discrimination, or other kinds of retaliation for engaging in whistleblowing activity or certain other activity. So again, that's another reason why my advice always is seek out a good employment lawyer as soon as you believe that you may have a problem, and that person can then help you navigate the landscape and make sure that you're going to the right place. And if nothing else, it'll save you a bunch of time. Again, I hope everyone's enjoyed this. My name is Alan Crone at the Crone Law Firm. Our number is 901-737-7740. That's 901-737-7740. Or you can find us on the web at CroneLawFirmPLC.com. And I hope you have a good weekend, and we'll see you next time on the Crone Law Firm Facebook Live.